Hello friends, today we'll be discussing a very important topic related to law of torts, and that is doctrine of sovereign immunity. Now what is this concept? Friends, the old and the archaic concept of sovereign immunity that king can do no wrong still haunts us, where the state claims immunity for its tortious acts and denies compensation to the aggrieved party. The doctrine of sovereign immunity is based on the common law principle borrowed from the British jurisprudence that the king commits no wrong and that he cannot be guilty of personal negligence or misconduct, and as such cannot be responsible for the negligence or misconduct of his servants. Another aspect of this doctrine was that it was an attribute of the sovereignty that a state cannot be sued in its own courts without its consent. The point as to how far the state was liable in tort first directly arose in the case of P&O Steam Navigation Company versus Secretary of the State. The facts of the case were that a servant of the plaintiff's company was proceeding on a highway in Calcutta, driving a carriage which was drawn by a pair of horses belonging to the plaintiff. He met with an accident caused by the negligence of the servants of the government. For the loss caused by the accident, the plaintiff claimed damages against the Secretary of the State for India. Sir Barnes Peacock, the then Chief Justice of the Supreme Court of India, observed that the doctrine that the king can do no wrong had no application to the East India Company. The company would have been liable in such cases, and the Secretary of the State was thereafter also liable. The court also drew the distinction between sovereign and the non-sovereign functions. That is, if a tort were committed by a public servant in the discharge of sovereign functions, no action would lie against the government. For example, if the tort was committed while carrying on the hostilities or seizing enemy property as prize, the liability could arise only in case of non-sovereign functions, that is, acts done in the conduct of undertakings which might be carried on by private persons, individuals without having such power. Friends, the aforesaid judgment laid down the East India Company had a twofold character: A, as a sovereign power, and B, as a trading company. The liability of the company could only extend in respect of its commercial dealings and not to the acts done by its in exercise of delegated sovereign power. As the damages was done to the plaintiff in the exercise of non-sovereign function, that is, the maintenance of dockyard, which could be done by any private party without any delegation of sovereign power, and hence the government cannot escape liability and was held liable for the torts committed by its employees. Now let us discuss the idea of sovereign and non-sovereign functions in the Indian context. As discussed, the aforesaid case was of pre-constitutional era, making the distinction between sovereign and non-sovereign function of the state, and holding the state liable in case of non-sovereign functions, which was also followed by the Honorable Appeals Court in its subsequent judgments in India. The point as to how far the state was liable in tort first directly arose after independence before the Honorable Supreme Court of India in the case of State of Rajasthan versus Musumati Vidyavati. This case was of 1962. In that case, the claim for damages was made by the defendants of a person who died in an accident caused by the negligence of the driver of a jeep maintained by the government for official use of the collector of Udaipur while it was being brought back from the workshop after repairs. The Rajasthan High Court took the view that the state was liable, for the state is in no better position insofar as it supplies cars and keep drivers for its civil service. In the said case, the Honorable Supreme Court has held as, quote, act done in the course of employment but not in connection with sovereign powers of the state. State, like any other employer, is vicariously liable. In this case, the Honorable Appeals Court while approving the distinction made in Steam Navigation Company's case between the sovereign and the non-sovereign function, observed that the immunity of the crown in the United Kingdom was based on the old feudalistic notions of justice, namely that the king was incapable of doing a wrong. The said common law immunity never operated in India. We must remember this. Another case in which the principle laid down in the steam navigation case was followed was Kasturi Lal Ralia Ram versus State of Uttar Pradesh. This case was of 1965. In this case, the partner of Kasturi Lal Ralia Ram Jain, a firm of jewelers of Amritsar, had gone to Meerut, was selling gold and silver, but was taken into custody by the police on the suspicion of possessing stolen property. He was released the next day, but the property which was recovered from his possession could not be returned to him in its entirety, inasmuch as the silver was returned, but the gold could not be returned, as the head constable in the charge of Malkhana misappropriated it and then fled to Pakistan. The firm filed a suit against the state of UP for the return of the ornaments and in the alternative for the compensation. It was held by the Apex Court that the claim against the state could not be sustained despite the fact that the negligent act was committed by the employees during the course of their employment, because the employment was of a category which could claim the special characteristics of a sovereign power. The court held that the tortious act of the police officers was committed by them in a discharge of sovereign functions, and the state was therefore not liable for the damages caused to the applicant. Initially, aforesaid principles laid down by the Apex Court were followed in the Motor Vehicles Act cases also. The question is, how far sovereign immunity is available in motor accident cases has, however, been the subject matter of the consideration in a large number of cases of the various high courts and as well as of the Supreme Court of India. It would be interesting to note that the aforesaid distinction of the sovereign and the non-sovereign functions of the state and denying the compensation in the case of sovereign functions were also extended to motor vehicle accident cases also. The cases were mostly those involving government vehicles, mainly military vehicles or paramilitary force vehicles. The trend of the judgments revealed that the court basically examined the question whether the military vehicle was engaged in the act which can alternatively be exercised by the private parties, or the act is of the purely sovereign nature, like act of war, movement of troops, and armaments which cannot be delegated to the private parties. Friends, let us now notice the relevant case laws on this subject. In Satyavati versus Union of India, 1957, the Delhi High Court bench, an Air Force vehicle was carrying hockey team of Indian Air Force station to play a match. The facts further are that after the match was over, the driver was going to park the vehicle when he caused the fatal accident by his negligence. It was argued that it was on the functions of the Union of the India to keep the army in the proper shape and tune, and that hockey team was carried by the vehicle for the physical exercise of the Air Force personnel, and therefore the government was not liable. The court rejected this argument and held that the carrying of hockey team to play a match could by no process of extension be termed as exercise of the sovereign power, and the Union of India was therefore liable for damages caused to the plaintiff. In another case of Union of India versus Srimati Jasau, this is a case of 1962 of Punjab High Court, a military driver, while transporting coal to General Headquarters in Simla in discharge of his duties, committed an accident. It was held that the mere fact that the truck happened to be an army truck and the driver was a military employee cannot make any difference to the liability of the government for the damages for the tortious acts of the driver, as such things could be obviously done by a private person also. In another case of state of Rajasthan versus Shrimati Shekhu and others, it has categorically ruled out the application of doctrine of sovereign immunity to the Motor Vehicle Act and held as, quote, after the amending Act of 100 of 1956, by which Section 110 capital A of the Motor Vehicles Act of 1939 was inserted, the distinction of sovereign and the non-sovereign acts of the state no longer exists, as all owners of the vehicles were brought within the scope of that section. Friends, Section 166 of the new Act of 1988 reproduced Section 110 capital A of the old Act. Whether the state is bound by the provisions of Motor Vehicles Act is no longer res integra. Now friends, let us analyze a recent case of 2008, which is Union of India versus Rasmuni Devi and others. In this case, which was decided by the Honorable Jammu and Kashmir High Court, the fact was that a military truck collided with the BSF vehicles and caused injuries to the standing constable of the BSF, who later on succumbed to the injury. The Honorable J&K High Court in this case did not consider the issue of sovereign immunity and awarded the compensation. No application of sovereign immunity to the negligence causing threat or deprivation to life under Article 21 of Indian Constitution, without prejudice to the aforesaid judicial pronouncement. Even otherwise, the concept of immunity in respect of sovereign functions has no application where the fundamental right to life as guaranteed by the Article 21 of the Constitution of India has been transgressed, as held in the judgment of High Court of Andhra Pradesh in Challa Ramkonda Reddy versus State of Andhra Pradesh, which was a case of 1989. In which it has been subsequently approved by the Supreme Court in State of Andhra Pradesh versus Challa Ramakrishna Reddy in the year 2000. From the said judgment, the following points emerged. Number one, the sovereign immunity is not applicable to the cases in public domain, that is, in the cases of writ petitions under Article 32 and 2 to 6 of Constitution of India. The principle is equally applicable to the private law domain, that is, claim of damages under tort law, where the right to life as guaranteed by Article 21 of the Constitution is violated, as the said right is sacrosanct, inalienable and indefeasible. Then secondly, it was also held that though the principle of Kasturi Lal case of 1965 is not applicable where the right to life as guaranteed by Article 21 is transgressed, in such cases, damages have to be awarded for the tortious acts of the government servant depriving the person of his life and the liberty, except in accordance with the procedure established by the law. The next thing which was observed in this case was that the negligent act causing the deprivation of life and the property of a person is to be held as a violator of fundamental rights to life as guaranteed under Article 21 of the Constitution of India. Last but not the least, the Honorable Supreme Court in this case has also concluded in the following words, quote, the law has marched ahead like a Pegasus, but the government attitude continues to be conservative and it tries to defend its action or the tortious action of its officers by raising the plea of immunity for sovereign acts or the acts of the state, which must fail, unquote. Now at the conclusion, friends, let us now understand the principle of sovereign immunity which has been ignored in the other cases. Friends, within authority, there are curtain of judicial pronouncements in which the judiciary has ignored the principle of sovereign immunity and also differed from the ruling laid down in the Kasturi Ram case and held the government liable for the tortious acts committed by its servants. The various cases are, for example, Saheli, a women's resource center versus Commissioner of Police, Delhi. This was decided by Supreme Court in 1990. The state was held to be liable for the tortious acts of its employees when a 9-year-old boy had died due to the beating by the police officer acting in the excess of power vested in him. The court directed the government to pay rupees 75,000 as compensation to the mother of the child. The another case is Common Cause, a registered society versus Union of India and others, which is the case of 1999 as decided by the Supreme Court. In this case, the entire history relating to the institution of suits by or against the state, or to be precise, against the government of India, beginning from the time of East India Company right up to the stage of constitution, was considered and the theory of immunity was rejected. In this process of judicial advancement, custodial cases, as already discussed, has paled into insignificance and is no longer of any binding value. Friends, last but not the least, it would be interesting to note that in Australia, also this doctrine of sovereign immunity has been ignored, as can be seen from the decision in Parker versus Commonwealth of Australia, where two ships of the Royal Australian Navy, viz. Melbourne and the Voyager, came into collision on the high seas about 20 miles off the Australian coast. Melbourne struck the Voyager and she sank along with some men therein, resulting in the death of one Parker. His widow brought an action against the Commonwealth for damages on the basis that her husband's death was caused by the negligence of the officers and the crew of the ships of the Commonwealth. The deceased Parker was a civilian employed by the Navy Department in a technical capacity. In those facts and the circumstances, Justice Vidyavati of the High Court of Australia held that the Commonwealth was liable in tort for damages and that the widow of the Parker could bring in the suit for damages for the negligent acts or omission of the members of the Royal Australian Navy. The plea of defense, based on the old and the archaic concept of sovereign immunity as borrowed from British jurisprudence prevalent during colonial rule, is based on old feudalistic notions of justice, namely the king can do no wrong. This common law immunity do not exist in the realm of welfare state and is against the modern jurisprudence of the world, where the distinction between sovereign or the non-sovereign power does not exist, and the state, like any ordinary citizen, is liable for the acts done by its employers, as has been ruled by the Honorable Apex Court and various high courts in their various judicial pronouncements. Moreover, as the said doctrine should not be applicable to motor accident claims under the Motor Vehicles Act of 1988, which is a beneficial legislation. Thus, from the above aforesaid judicial pronouncements of the Honorable Apex Court, followed by various High Courts' decisions, it is established that the sovereign immunity to the claims under the Motor Vehicle Act is no longer res integra. So, therefore, we understood the concept of sovereign immunity does not hold good in the Indian scenario. Hope you have understood the topic well. Thank you and goodbye.